Stefan Talmon, who joined Oxford University in 2003, is a tutorial fellow in law at St. Anne's College and is the course director for public international law in Oxford's Foreign Service program, in addition to his professorial responsibilities. Talmon was previously both an assistant and an associate professor at Tübingen University. His legal opinions have ranged from international environmental and criminal law to law of the sea, and from human rights to terrorism. He has received a number of honors that include an award from the German Research Foundation and the German Foreign Service Office for his habilitation thesis, the Teacher of the Year Award from the Federal State of Baden-Württemberg, and a Rhodes Fellowship. He is a member of several professional societies, including the Society of Legal Scholars, the German Society of the United Nations, International Law Association, and the American Society of International Law. Dr. Talmon received an MA from Oxford University and became a member of the German Bar in 2003, and a DPhil from Oxford University in 1995, and an LLM from Cambridge University in 1989. Today he will be speaking on the topic of the EU as an actor in international law. We'd like to especially thank Ann Tolley, who has worked with Dr. Talmon as a research assistant, for her efforts in making this visit possible here to the Kennedy Center. So please join me in welcoming Dr. Talmon.
Thank you. This is a lovely room to speak to you, and my topic today, the European Union as an actor in international law, and I didn't really know what to expect when I was asked to speak to you. I didn't know what the level of knowledge of European law was, and so what I've tried to do is to bridge the gap and go from the pretty obvious and easy to the more complicated. I would like to start with a little anecdote. I flew to the United States on Sunday. When I booked my ticket online, I had to tick a little box which said that I'm happy that all my data the airline company holds on me will be passed on to the Department of Homeland Security in this country. The day before I left, I received an email which said that I hadn't provided the Department of Homeland Security with my advanced passenger information data, and I was required to fill in a little questionnaire again online. Now, you might ask, what does that have to do with the European Union as an actor in international law? The whole thing started, of course, with September 11th. After September 11th, the US adopted a law which required all airlines flying from Europe to the United States to provide the Department of Homeland Security with information on their passengers. At the time, the US government asked European airlines to allow them direct access to their computers in Europe so that they could pull all the data from the computers in Europe basically to the computers in the United States. Now, this was a problem for the airlines because we have a European Union law which says that you are not allowed to pass on personal data to anybody unless you are required to do so by law. Now, the European airlines had a problem. If they didn't supply the data to the Department of Homeland Security, flights might have been delayed, landing rights might have been denied, or there would have been long queues entering the United States because every single passenger would have been asked on arrival to give all this information the airline holds. So what the airlines did was supply the information or give the Department of Homeland Security access to the information, thereby violating European data protection law. For about 2.5 years, the European authorities looked the other side, not seeing that there was a violation of European law. Because if European law had been enforced, basically all the European airline companies would have gone out of business tomorrow. Because the American airline companies would have supplied the data, the Europeans wouldn't. Now, how was that problem solved? It was solved by an agreement between the European community on the one hand and the United States government on the other hand. It was a kind of compromise deal that was reached after 2.5 years of negotiations. The Americans no longer required 68 pieces of information and now only require 34. You see, a typical compromise. Yeah? On the other hand, if you are now flying to Europe, you also have to tick this little box that you are prepared to give your data to the European security agencies. And you probably receive a little email if you haven't filled in your advanced passenger information. Now, the whole thing also legalized the practice of US law enforcement agencies having access to European computers, because this is a problem in international law. You might have heard about the sovereignty of states. Some writers these days claim this is a thing of the past, but states still assert their sovereignty. And so the European states said, no American law enforcement agency may actually access European computers. If we have this agreement now, the whole thing is legalized, because we can say the Europeans now consented to the Americans having access to the European computers. So the agreement between the European community and the United States was required for two reasons. For a European law reason, basically the data protection law, and for an international law reason, so that the United States could exercise some powers within European territory. Now, there is one little problem. The agreement was concluded by what is known as the European Community, represented by the European Commission. And one player I haven't mentioned so far is the European Parliament, which took issue with that matter and has now taken the European Commission to court in Europe, challenging the powers of the Commission to conclude such an agreement with the United States. And the decision is still pending, so we are still making our little cross, so we are ticking our little box until the European Court of Justice has ruled on that matter. One example of Europe and international law. The other example I want to present is the WTO, the World Trade Organization. You might have heard that there have been around 400 cases before the various panels of the WTO on various trade issues. The majority of these cases concern the United States on the one hand and the European Community on the other hand. It's no longer the individual member states that are acting. So it's no longer Great Britain, France, or Germany which is taking the United States to court or before an arbitral tribunal. It is now the European Community acting. And sometimes the European Community, represented by the European Commission, is even acting against the express will of some member states. So even if France and Germany or the UK say, no, we don't want to take the United States to court over this issue, the European Commission will still take the United States to court in the European interest. The European interest is more than the individual interests of the member states. Just on the 1st of October this year, there was an important ruling by a WTO panel against the United States in a case brought by the European Community. I don't want to bother you with the details of the case. The case concerned a US tax law, which was considered to provide illegal export subsidies to US manufacturers. So the WTO panel now ruled on the 1st of October that the European Community may impose $4 billion of sanctions of $4 billion on the United States So on various exports of the United States to Europe. So we may levy taxes on corn, on computers, on cars, up to $4 billion. This is just the start. On the horizon, a much bigger case is looming between the European community and the United States. You might have heard about the battle between Airbus Industries and Boeing. Both the United States and the European community accuse each other of subsidizing these aircraft manufacturers. And they have both taken each other now to court. They have both taken the case before a WTO panel. Now you could say the Europeans here have a slight advantage, because even if the Europeans are losing on the Boeing-Airbus case, we still have the $4 billion to bargain from the latest ruling. Again, you see, it's not the member states that are acting on the international plane. It is the European community. Just to add something with regard to the WTO and the European community. When President Bush started his re-election campaign, the European Commission targeted so-called marginal states in the United States with sanctions from an earlier WTO ruling, thereby putting pressure on the Bush administration to change the laws. Because there were certain states where the run was very close, and so the European Commission drew up a list and said, if you will not act on one of these WTO rulings, we will exactly target these states, and that will basically lose you the election. Of course, the US is acting in a similar vein. If, for example, Italy violates WTO law and has unfair trading practices which affect the United States will no longer target Italy with the sanctions, because it can now target the whole European community. So what the United States will do, it will target car manufacturers in Germany. It will target French cheese, because France and Germany are important members of the European community. And thereby, the United States administration will exert pressure on these countries to then work within the European institutions to change things. One third example I want to give you how the European community acts on the international plane. And this is a national legal issue of the United States, a case before the United States Supreme Court, decided in 2004. And the lawyers of you will know this case. It's called Sosa versus Alvarez-Machain. This case concerned an action under the Alien Tort Claims Act. The Alien Tort Claims Act is a US statute from 1756 or 1786. I'm not quite sure, but the 18th century. This statute gives a civil cause of action to victims of serious violations of international law. So everybody from all over the world can come to this country and bring a claim against anybody else in the world for violation of international law. So what the United States is doing with this act, it is actually claiming a universal tort jurisdiction. It plays the courtroom for the world in that respect. Now, in this case, the European community filed an amicus curiae brief. Now, you may wonder, what does the European community do before the US Supreme Court? It basically informs the US Supreme Court about its opinion on international legal issues. If you file a brief before the United States Supreme Court, you must have a special interest. And of course, the European Union or the European community claims to have a special interest whenever the United States adopts or applies a law with extraterritorial application which has effects on European law. So whenever the United States now basically adopts a law which may have effect on Europe, Europe claims an interest and may bring such a brief to the US Supreme Court. And the US Supreme Court accepted the European Community's brief. These are just 3 examples where the European Community plays a role on the international plane. I could just mention a few more. The European Community regularly imposes sanctions on other states, not just sanctions that are authorized by the Security Council, but are also sanctions which the European Community decides on its own. The European Community sees itself as an advocate for human rights obligations worldwide, in a similar vein as the United States. So the European Community has started to include in every treaty it concludes a so-called human rights clause. And recently we have included a democracy clause and a nuclear non-proliferation clause. This allows the European Community to exert pressure on third states. As soon as these third states violate these clauses, either they violate human rights, they trade in nuclear weapons, or they do not live up to our democratic standards, the European Community now is allowed to suspend or terminate these treaties. The European Community is also active in peacekeeping missions. Up to 2004, NATO and the United States, of course, had up to 60,000 troops on the Balkans, in Bosnia-Herzegovina and Macedonia. In December 2004, the European Union took over that peacekeeping mission in Bosnia and Herzegovina. But the European Union is not just restricted to Europe with its peacekeeping missions. The European Union has started a by now it's already finished again, has had a peacekeeping mission in the Democratic Republic of Congo in Africa. And just on the 15th of September, the European Community has started a mission in Indonesia, in Southeast Asia. So the European Community is acting more and more as a player on the world stage. Now, I've talked about the European Community and I've talked about the European Union. That is all very confusing. You must distinguish between the European Union on the one hand and the European Community and certain other policies on the other hand. And that's why I want to use this little picture here to symbolize. The European Union is like a house. And the roof you could call the European Union. And the European Union is made up of 3 rooms, or 3 columns, you could say. And one column of the European Union is the European Community. The others are the common foreign and security policy and the policy on justice and home affairs. Now, things have become more complicated in recent years because up to a couple of years ago it was only the European Community that was acting on the international plane. Why was that so? Because only the international community was perceived to have international legal personality. If you want to act on the international plane, you must be a subject of international law. The European Union, and that's even disputed between European law scholars, does not yet have international legal personality, whereas things are developing. And if I tell you that the European Union recently has concluded treaties, then this is one indication that other states accept that it has a certain international personality. But let's get back to legal personality, if you want to interact as European community with the United States under international law, in the international legal framework, you must be a subject of that international law. You must have international legal personality. And how does an institution such as the European community get international legal personality? We all know the prime example of an international legal person is the state, and has been for the last 400 or 500 years. Now, how does an international organization become an international legal person? First of all, it has to claim to be such a person. So the states constituting the organization must confer legal personality on that entity. And the European states have done so in Article 280 of the treaty establishing the European community. There it says, the European community shall have legal personality. Now you could say the United States couldn't care less what the Europeans write in a treaty and whether they want to establish an international legal person or not. That's true. And for a long time, the United States was very reluctant to accept the European community as an international legal person. Because in the United States, the belief was, oh yes, today the European community, tomorrow it's gone again. What will remain are the member states. Great Britain, France, Germany, Italy will not disappear. But the European community is probably just a one-day issue. So for quite a while, the United States did not accept the European community as an international legal person. So they said, we want to conclude treaties with all the member states instead of concluding a treaty with the European community. And the Soviet Union actually sticked to that position until 1988. Only 2 years before the Soviet Union was dissolved, the Soviet Union still believed that actually the European Union or the European community would go away again. So basically we can say the European community has at least survived the Soviet Union. It's now generally accepted that the European community has international legal personality and can act on the international plane. It acts on the international plane mainly as European community, and I will concentrate on the European community. The European community as a subject, as a person in international law, acts through its organs. And there are several organs. There is the Council of the European Community, there is the Commission, and we also have something that is called the High Representative for the Common Foreign and Security Policy. He is normally one who is just acting in this column, in this room. But his role becomes ever more important, and probably he is acting now in the whole area. You might have heard of this person. It's Javier Solana, a former Spanish foreign minister, and he is also sometimes called Mr. Europe, or the face of the European Union and the European community. I want to briefly deal with some peculiarities of the EC legal order which impact on the foreign relations. First of all, the member states, the 25 member states of the European community, are the ones who are really fully sovereign, who have the full range of powers under international law, as sovereign as, for example, the United States. These states have decided to confer powers, confer sovereign powers onto a higher level, to the European community. By conferring these powers, the member states have lost the powers. So in future, it's just the European community which will act in these areas where power has been conferred onto the European community. So the member states are no longer competent in areas of agriculture, fisheries, trade, tariffs, custom, you name it. In this area, it is the European community which acts both internally and externally. And that means it is acting as an international actor for customs, tariffs, and so on. How are these powers conferred from the member states to the higher level, the European community? This may be done expressly in the treaty establishing the European community, but, and that's more important, it may be done implicitly. And this is now the jurisprudence of the European Court of Justice. The European Court of Justice, in a landmark ruling in 1962, said, whenever the European community has internal powers, it automatically also has external powers. And that widened the powers of the European community as an actor in international law tremendously. And there is yet another way to confer powers, and this is an ad hoc way, when there is no basis for acting externally. All the 25 member states can agree that it is better for the European community to act than it is for them to act alone. I want to move on to a specific issue, which is the treaty-making power. Most of international interaction these days is through treaties. Between 2000 and 2005, the European community has concluded more than 400 treaties. This means it has concluded more treaties than the member states itself, because more and more areas are now within the competence of the European community. So the member states no longer have power to act externally in these areas. And as I already mentioned, these are areas like customs, tariffs, and trade, transport, road, rail, and most recently even air transport, monetary matters, financial assistance, development, personal name record data, what I just described to you, ticking the box when you want to fly to the United States, the mutual recognition of certificates, of academic degrees. The European community and the United States have recently concluded an agreement on basically acceptance of maritime certificates. Other areas concern visa, readmission, extradition. The United States and Europe have concluded an extradition agreement. So the United States no longer concludes extradition agreements with individual member states. The same applies to agreements on legal assistance. So all these treaties that existed between the United States and individual states like the United Kingdom or Germany have been replaced by one general treaty, which the United States now has with all the 25 member states in the community. Now, what happens if member states would nevertheless conclude a treaty in such an area? Internationally, they would be bound by that treaty, because we still have the international legal order. If you as a state engage in treaty making and you make a treaty with another state, then you are bound by that treaty. But for the European states, that now means they are violating European community law. So if, for example, the United Kingdom would conclude a treaty with the United States in an area where there is no competence for member states, the European Commission will take the United Kingdom to court, to the European Court of Justice, and the European Court of Justice will then rule, you, United Kingdom, are no longer competent to conclude that treaty. The first consequence will be that the United Kingdom is asked to terminate that treaty, and to help the United Kingdom to do that, normally a fine will be imposed, like basically 30 million a month if they don't terminate that treaty. So they can choose whether they actually want to violate international law, basically their treaty obligations under international law to the United States, or whether they want to violate their obligations under European Community law. Now, one tricky issue with regard to treaty making are mixed agreements. I don't know whether you have heard about mixed agreements before. Mixed agreements have to be concluded in all cases where a treaty touches upon matters that are in the area of competence of member states and in the area of competence of the European Community. So you may have like Articles 1 to 5 of a treaty concerning the competence of the European Community. But then Articles 6 to 10 are in an area where there is no competence, where there are the member states which are competent. Now, how do we solve that problem? We solve that problem by concluding so-called mixed agreements. And the European Community and the member states appear as one party on one side, and the United States is the opposite party. But this creates a lot of trouble, both for the European Community and the member states, and for the United States. Just think about it. What happens if this treaty is violated? How do we know who is responsible? Is it the member states the United States has to turn to, or is it the community it has to turn to? My example was pretty obvious and pretty easy by saying Articles 1 to 5, European Community competence, 6 to 10, member state competence. But life isn't as easy as that. Probably you'll have competence areas within Article 1, which are partly community and partly member state. So how do you solve that problem? I've just attended this morning a class here on US tort law. And what I've learned is about joint and several liability. Now, that means both are responsible. The United States can choose. It can either go after the community or it can go after the member states. Unless, and that's something the European Community has developed to protect itself against basically multiple claims, unless the European Community has made an express declaration of competence, outlining in what area the European Community is competent and in what area the member states are competent. Another problem for the European Community is treaties that only allow state parties. Lots of treaties, especially the older treaties, only allow for states to become party to a treaty. Now, what if this treaty governs an area that is within the exclusive competence of the European Community? So, the member states are no longer competent to conclude the treaty according to EC law, to European Community law. But the European Community that is competent cannot conclude the treaty because the treaty is only open to states. This problem has been solved by a concept that is called trusteeship. That means that the member states are acting as trustees for the community. But that doesn't mean that every member state can decide, I will now act as a trustee and conclude this treaty. Now, you need a decision by the European Community organs which allow the member states to sign such a treaty in the interest of the European Community. But it's of course not just treaty making where the European Union or the European Community acts on the international plane. Membership in international organizations is another problem. In areas where the European Community is competent, it will have to join international organizations. It will have to replace the member states. And that has happened in such areas as agriculture and fisheries. The United States And these days, the European Community are members of the North Atlantic Fisheries Organization, together with Canada. It's no longer England, France, or the individual member states. But again, this causes certain problems. What about the voting rights in such an organization? There are 25 member states. Is the European Community to have 25 votes in such an organization? Is it perhaps even to have 26 votes, namely one for the European Community and for the 25 member states? Or is it to have just one vote, because it's the European Community that is a member? What about contributions to the organization? Do we have to pay for 25, for 26, or do we say, oh no, we are just one member, so we only pay for one member? Even more critical is the question of representation in organs of such organizations. You know, a lot of things in international organizations are hammered out in little committees, and so it's very important who is on the committee. Is it a member of the European Commission who is representing Europe in that committee? Or is it a representative of the member states? Or is it perhaps the Council presidency who is representing the European Community? Problems over problems. One last problem I want to mention that has only recently arisen is diplomatic protection. You all know that your state may exercise rights of diplomatic protection for you. If you are maltreated abroad, the United States government may protect you on the basis of your nationality, because you are US citizens. The same applies to US companies. The United States may take up the cause of a US company abroad. Now, this is because the company is incorporated under US law. That's the link between the company and the United States for diplomatic protection. Now, the problem with Europe is that half a year ago, we have introduced a European company law, which says there are no longer English, French, German companies. There is now only a European company, or you can choose at the moment to be a European company. And in probably 3 or 4 years' time, everybody will have to adopt this European company status. Now, who is going to protect you abroad? If, for example, British Petroleum would be maltreated in this country for various reasons, who is to take up the case of British Petroleum against the United States? Is it Britain, or is it now the European Community? It is no longer incorporated under British law, so there is no link to Britain anymore. The link is now to the European Community. I've tried to outline several of the problems, and I'm giving normally a course which is 32 hours, so I could go on and outline some more problems. But I hope I've shown that for the European Community to replace the member states in certain areas has created opportunities, but it also has caused problems. Some of those problems have still not been solved. But they show one thing. The European Community has to think whether it has to adopt a kind of statute status to play its full role in the international community. So whether the European Community should become state-like, like the United States of America, or whether Europe is influential enough on the international plane actually to remodel the international legal system so that it fits in better than in the old state-centered international system. Thank you very much, and I'm happy to take your questions. Yes.
Thinking about the EC compared to the EU, what type of benefits or advantages individual states just because it seems more like it would be harder to adhere to the individual wants and more, I guess, kind of more less democratic. But just how do you go about adhering to those individual states' needs and wants through an entire European community when you already have the EU doing something of that sort?
I don't quite understand your question. Could you rephrase it?
Let's see. Well, how do they go about making treaties? Like you said, the EC has done over 400 so far.
Yeah.
And do they go in with the individual states and talk with the representatives from there? Or how do they go about doing that?
There is one principle in European community law which says that only the Commission, the European Commission, has the right of initiative. So the European Commission will say, oh, it would be a wonderful idea to conclude a treaty with the United States on air services, for example. It would make a proposal to the European Council. The European Council is the body that represents all the 25 member states. Everybody has one member on the Council. The Council will then adopt a decision and will give the Commission a negotiating mandate. And in that decision, the parameters of that negotiating mandate is set out. And then the Commission will sit down with the United States and will negotiate the treaty. This treaty will then be brought back to the Council, and the Council will then approve of that treaty. That's how it works. Yes, please.
Do you see this increased power of the EU or the EC in the international legal arena as a way of perpetuating the existence of the EU or solidifying its role? And how or why?
I'm sure that probably most European member states have by now realized that they are stronger as 25 than they are as one, and they are reaping the benefits in many areas. At the moment, the Europeans are trying to negotiate an air services agreement with the United States. And of course, Europe as one bloc has much more power in these negotiations than, for example, Italy would have, or think about Luxembourg. But if you appear as 25, you have a power base and you have a negotiating position which probably no one else has apart from the United States and probably China these days. And I think for that reason alone, the European Union will continue on that path. Yes, please.
You mentioned that each member state gets a vote on the council, right? Mm-hmm. Is there some kind of a representation or some kind of a proportional representation for larger states? For example, France over Luxembourg or something?
Yeah, there is a complicated procedure for the votes, or each country has a different number of votes if we are voting in a qualified majority procedure. If we are voting in a unanimity procedure, it's just one member, one vote. But in the qualified majority procedure, the larger states have more votes than the smaller states. Yes, please.
Is the European community the international actor branch of the European Union? What is?
No, the European community is the actor for the competence area of the European community. In that area, the European Union also acts as an international actor, but I didn't want to go into too much detail. In that area, you will just deal with the European Union, but the European Union still has no legal personality. So although you will be discussing things with a representative of the European Union, by concluding a treaty with the European Union, what you do is not conclude a treaty with the European Union, but with the 25 member states that are behind the European Union. So basically, you get 25 treaties by just negotiating with one. So it's a one-stop procedure. So whereas here, you're just getting one treaty, namely with the European community. But the European community, by concluding this treaty, makes it European community law. And as community law, it is binding on all the member states. Whereas in this case, the treaty is binding on the member states as treaties under international law. That's the difference. Yes, please.
In that mixed agreement treaties, do the states still retain some kind of sovereignty? Like, if one of them didn't want to sign it, would it nullify it for all of them, or would they have to sign it?
No, mixed agreements are governed by two principles in European law. The principle of cooperation and the principle of unity of representation. So we will only conclude a mixed agreement if there is agreement within the member states. Again, the same procedure applies as I've outlined. The Commission will come with a proposal. The Council will adopt the proposal, will give a negotiating mandate, and then, because we have unity of representation, either the Commission or now these days the High Representative will negotiate the treaty. So you won't have 25 member states sitting at the table. The negotiating mandate is drawn up in beforehand, and you have your parameters in which to negotiate. Yes, please. Yes.
Okay. You talked about the EU gaining their their legal personality, and how the U.S. had a hard time accepting it as a legal. And what was the trigger that let them recognize them as a personal or a legal personality?
The economic power. With growing economic power on the part of the European community, the US was more and more forced, because at one stage it was the US who wanted to conclude a treaty with the member states, and not the member states wanting to conclude a treaty with the US. And at that stage, the member states could say, we are no longer competent. If you want to have an extradition treaty with us, you must go through the European community. And so the US was forced, just by the realities on the ground, to accept the European community as an actor.
Once the United States accepts the European community as an actor, do you predict that over the next 10 or 15 years you will see that dyadic relationship, one-to-one, smooth things out in the legal system between the United States and Europe, or should we expect that partly as a result of the increasing power of the European states together, that we'll actually see more legal contention, or is it irrelevant to the amount of legal contention that you'll get between the U.S. and Europe?
No, I'm sure you'll get more in all different areas, because at the moment, and this probably relates to another question, I have the impression that for many people in Europe, Europe defines itself in opposition to the United States. So if you look at areas like the International Criminal Court, where the European community took the opposite stand to the United States, it's basically a rush for third states. The US and the European community are competing for third states. You know that the US is withdrawing development aid if countries do not sign an Article 98 agreement concerning the International Criminal Court. And the next day, the European Union representative comes and says, if you sign such a treaty, you will lose European Community Development Aid. So third states are basically in the position that they have to choose between the US and the European community. And just recently, I don't know whether this has been reported in the media in this country, the European community has taken a stance against the United States with regard to the governance of the Internet. The European Union has switched sides probably 3 weeks ago and is now siding with developing countries, claiming that ICANN, the International Corporation for Assigned Names and Numbers, should be removed from the United States law and should be put under the authority of the International Telecommunications Union. We could go on international environmental law, the Kyoto Protocol, how we protect the ozone layer. Again, the European community takes the different view of the United States. And trade disputes will probably become more severe over time, the harsher the competition gets. So I think I see even more problems, especially as more and more people in Europe see Europe or see a kind of European identity or define a European identity as a kind of anti-American identity. Oh, sorry. Shall we take two more? Shall we? Yeah, one more.
Could you talk more about your last comment Europeans have to choose whether the EU becomes more state-like or whether the EU becomes a basis for a new international legal system. What are the options there? Are you talking about regional governments?
No, it's just whether international law will remain as it is, basically a state-centered system, and then the European Union will have to choose whether either to play a full part, and that means becoming a kind of state-like structure, or basically playing a lesser part, because you can't play your full role. The European community could not go before the International Court of Justice. The European community cannot sign many international important agreements. The European Union cannot even sign the European Convention on Human Rights. So either you have to become a state to do all this, or you have to become powerful enough to force others or to make others agree that the system is changed in such a way that it provides for a kind of new actor which is somehow between states and the classical form of international organizations, the so-called supranational organization, which basically accommodates the peculiarities of the EC legal system within the international legal system.